So, Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, best wishes to all of us. I think it's wise for me to firstly introduce myself. My name is Gabriela Jocelyn. You can call me Gabby, and I will be today's Master of Ceremony. I would like to express gratitude for the opportunity so we're all able to attend to today's Kuliah Tamu held by Faculty of Law. Under the topic of tort conducted by administrative bodies, comparative law perspective between the Netherlands and Indonesia. Now, before we move on to the main event, I would like to welcome the Vice Dean for Research, Community Service, and Information System, the Honorable Dr. Heribertus Jakatriana, SHLLM MA. How are you doing today, Pak Jato? Okay, that's great. Furthermore, allow me to express my welcome to the representatives of LO, LSO of the Faculty of Law, as well as to our amazing speakers here today. We have Professor Dr. Albertjan Tolenaar, did I pronounce that correctly? Okay, who came all the way from University of Groningen, along with Dr. Rico Andi Wibowo, one of UGM's lecturers. Mas Rico and Prof. Tolenaar, how are you doing today? Okay, that's great. And I'm assuming everyone else here today has the same energy and enthusiasm to listen to the materials that will be brought up today. So lastly, it's also important for me to introduce our wonderful moderator, Mas Adrianto Budi, who will be moderating the speakers and make sure that the discussion runs smoothly. So, Mas Budi, how are you doing today? Great, okay. On the next agenda, allow me to firstly read out the schedules for today's seminar, which will include the following, which is firstly the opening, and second we have greetings from the Vice Dean, the speakers, and introduction from the moderator. And thirdly, we have discussion session, which will be 30 minutes from each speakers. And fourth, we have question and answers, and that will be 15 minutes, and then the closing. Okay, so now that we have that settled, perhaps I would like to welcome Pajeto as the Vice Dean for Research, Communities Service, and Information System to give us his opening speech. Pajeto, the floor is yours.
Thank you very much, and good morning, everyone. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, shalom, Om Swastiastu, Namo Buddhaya, salam sehat, rahayu buat kita semua. First of all, Bedang for UKOMS, Professor Andri Tolenaar, NAR Indonesia. Thank you very much for coming to this faculty, and I think it is a great opportunity for us to develop our future cooperations between Faculty of Law Gadjah Mada University and Reich University of Groningen. It is also my privilege as one of the alumni from Reich University of Groningen to welcome you in this particular event. And we hope that your lectures will give new horizons for our students to study more on administrative law as well as other law in their future professions. Greetings for our deans, Ibu Dahliana Hassans, to you, and best wishes to you and to all of us. And thank you very much for coming once again, and we hope that these lectures will, give benefits to all us. Thank you very much.
Okay, thank you so much, Pajeto. So, on to the next, I would like to call on Prof. Tolenaar and also Mas Rico to respectively introduce themselves and give out their opening remarks.
Sit here, yeah? Okay, welcome. Thank you so much. My name is Albertjan Tolenaar. I'm the director of the Graduate School of Law at the University of Groningen, but I'm also the professor of local law and governance. And in that capacity, I'm here. So I try to tell you something about, the local, the tort law, state liability, and especially in the local context. And since I'm also interested in the governance issues, I'm very interested in what actually happens with these rules. Now, I presented a presentation, and I will try to make contact with the one that hopefully can now open my presentation. There it goes, yes? Yes, thank you so much. Thank you so much. I will present my presentation. it will hopefully, well, I hope you'll understand it, but I tend to, when I get enthusiastic, I might talk a little bit too fast. And if that happens, you just have to notify me by raising your hand or asking questions, because then I slow down again. Can you publish it on the screen like bigger, because now it is only small. I'm not sure if everybody can read it. Let's hope that he knows how to do it. Okay, but the first slide already says my interest is, and now it's gone, is about state liability. And the question that I want to raise to discuss with you is, what happens if the government, next one, next one please. What happens if the government causes you any harm? Can you? Yes, thank you. What happens if the government causes damages? If the government does something that harms you, what is then the consequence? Can you put the next one on? And yes, and to illustrate this, I have 4 examples in the Netherlands, and these might be very strange for you, but these are recent debates on situations where the government did something that indeed caused damages. And then the question was, is there a reason for compensation? Is there a reason to hold the state liable and to get money from the government to compensate for the loss that the citizens faced? And I will go clockwise. You will see on the left top, you will see a house with a big crack in it. This is something that happens now in Groningen. We have earthquakes, and these earthquakes are not very serious compared to what you face here in Indonesia. Only 2 point something on the scale, you know, so not very severe. But the big issue is, it is very locally, only in Groningen. And why is it over there? Because we do something that's called mining. They extract gas, and you know one thing for sure: if you take something away under the soil will move. And that happens now, and sometimes the soil moves a little bit unequally, and then you have these cracks. And the interesting thing is, you could say, okay, but this is caused, so this is not caused by a natural cause, like you would have here in Indonesia, seismic tensions, and then there is an earthquake. This is caused by someone that is doing something, and that is mining, extracting gas. And then the issue is, that is done within a permit, based on a permit. So the question will arise, or arises now: can we hold the state liable for the consequences of this mining? Not only the mining company that actually did the mining, but perhaps also the state. Clockwise, right top, you will see a pollution. And that's also an interesting case. It's a very a current case at the moment. That is called Urgenda. That is the situation where an NGO, Urgenda, sued the state because the state did not do enough to combat the carbon dioxide emissions. Due to carbon dioxide is a cause for climate change, etc., etc. So, and the question is that unlawful that the state does not do enough to prevent carbon dioxide emissions? So that's another case. And then I will go bottom. You see on the bottom side, you see 2 demonstrations, but right bottom, you cannot read it, it's in Dutch. But it says, this was a demonstration after the lockdowns. In the COVID times, you had it here as well, we had lockdowns and curfews, etc. And there were some industries that were suffering a lot, especially the cafes, etc. When you have to go in lockdown, you don't make any money. So they were demonstrating against that. And the question was, is it lawful what the government does? Closing down your cafe due to the COVID crisis, etc., etc. And then the last one, that is on the left bottom side, that's a very interesting one. It might be very difficult for you to understand what's actually happening, but I will try to explain it in a way that it makes sense to you. We had a child benefit scheme. And this child benefit scheme was simple in the sense that you would receive a sum of money, but it was difficult in essence in the way it was implemented, because the sum of money depended on the predicted income you would receive during a year, and the predicted hours that you would send your kid to the daycare. And well, the predictions never come out, right? So sometimes you earn more money, happy for you, but then you had to repay your child benefit, or sometimes you did not send your kid the hours that you assessed in advance to the daycare, so to say. And the funny thing is, so quite often people make mistakes, and if you make a mistake, you have to repay. And now the interesting thing happened, that this was quite often a big sum of money that you would have to repay, because you had to repay everything. And what was interesting, and what was actually the problem, is that the government did a very strict supervision, but only on specific cases. And who were the ones that were subject to this strict supervision? Those with a specific family name, quite often Turkish or Moroccan. So there is a kind of a discriminatory action in the tax office, and they said, yeah, we base this on risk assessments. We think that these groups commit more fraud than others. But you can say already, you're lawyers yourself, this is discrimination, right? So, and that was a big issue, and the government even collapsed. So the minister had to resign, and we had new elections after this. So this, and you see here, the government does something, and it causes damages. And then the question is, in all the 4 cases, is there some government action here? Yeah, quite often there is. There are damages, people face negative consequences, and is there a reason to compensate for that? And if so, in which procedure? What is the procedural perspective? Can you click the next one? Next slide, please. Yes, thank you. And that's actually what I've written down in this slide. Someone has damages, the citizen has damages. It is caused, or there is some governmental action involved. Someone from the government did this. It's either the legislator, it might be a civil servant, might be the tax office, might be due by a decision. And that then gives rise for 4 questions. That's first of all, what is the actual governmental act that committed this problem? When is that governmental act unlawful? What is the test that you will have to apply to say this is unlawful what the government did? If it's unlawful, is there a reason for damages, for compensation? And then via which procedure? And the last one is perhaps even the most interesting one, because here you can compare with Indonesia as well. Yes, can you click on the next one, please? So the first question what is interesting? Why is this interesting? Because it's interesting because I tell you about it, but it's also interesting because this is a topic that shows that the boundaries between the public and the private order are not so strict as you might think. In essence, and this is Ulpianus, the guy that you see here, it's a Roman philosopher, so he lived 2,000 years ago. It's always good that you know your classics, Ulpianus. Don't forget it, Ulpianus. And he wrote this, Jus publicum est quod ad statum rei Romanae spectat jus privatum quod ad singulum ultimatum. That means what is public, what is private. The public deals with the public interest, what is for the public, what's for us all, for the collectivity, so to say, and what is private. So he suggested that there was a strict boundary between the public order and the private order. And the interesting thing with this whole tort law, state liability, is that, and that's actually the concluding remark, so I already give that away, the boundaries are not so strict. Here you will see that government is also liable under civil law procedures, civil law reasonings, and sometimes the state is just like an ordinary person, so to say. Interestingly, by the way, and that's why it's interesting for you to know, this idea of Ulpianus is still relevant in some jurisdictions, like France. They have a very strict boundary between the public and the private order. And in other countries, like UK, English law, there is no strict law. They have just common law, everything is under the law, etc., etc. So some countries are more stricter in this sense than others. And the Netherlands is always a little bit pragmatic. We have indeed a public order with special public order rules, so to say. But here you will see that there is also some part of it is regulated under ordinary private law, so to say. Yes, next please. So the first question: what are the causes of the damages? What caused the damages? Well, there might be different causes, of course, and actually we quite often make the biggest difference is between factual and a legal act, so to say. Factual acts is not the most interesting one. Well, it is interesting because it happens a lot, that the government does something in his capacity as a government and causes damages and then had to repay. Here you see a picture of a garbage car collection. and he hit a wall. Well, that is factual behavior. It causes you damages, but there is no question at all that that has to be compensated, and that is done under normal tort law rules. Quite often, it's just a matter of an insurance company that will take over the problem, etc., etc. In reality, it happens a lot, or it happens. This is something that happens a lot. From a research perspective, this is not the most interesting one, because it is rather straightforward, normal, ordinary law rules, so to say. There is only one thing that might be interesting here. Sometimes we see that factual behavior, factual acts, and might also be factual behavior by others than the government, that the lawyers try to search for ways to involve the government and say that it's actually related to something else, and that is an administrative decision. And the example that comes to mind then is the situation like this. We had a few years ago, we had a mass shooting in a shopping mall. Mass shooting was not like you hear in the US, but some people died, so it was not good, but so it was a mass shooting in the shopping mall. And it turned out that the guy that did this, he was mentally disordered, disrupted, and that makes sense, because who would do this in a rational way, right? But anyway, he went to the shopping mall and committed this crime. Well, he was, I think he was killed or taken into custody, but that doesn't really matter too much. The point was that there were victims, and the victims tried to sue both the one that committed the crime, like you caused me damages and I want to compensate that. I had hospital bills or whatever. I could not make money, whatever. But they also tried to sue the government. And why did they do the last thing? Well, they also opted for the last procedure. Well, because the guy had a permit to hold a rifle. And in having this permit, you could say the government made a mistake. Apparently, the government should have kept more supervision, should have prevented this from happening. Under the fact that there was an administrative decision involved, the one that had damages tried to involve the government as well. And you can imagine why they did that, because if you can sue the government and you are successful, the government has big pockets. You can you will get more compensation. I mean, the actual offender, he went bankrupt, so you then don't get any compensation. So it's always good if you can involve the government in one way or another. That was the idea. So sometimes you will see that even with factual acts, and that these factual acts can be done by governmental persons, but also by private persons, they is then the lawyers, try to involve the government in its capacity as administrative body, responsible for either supervision or having issued a permit, try to involve the government as well. Then we come with the second category. Actually, so these were factual acts, and then we have the legal acts, and then the legal acts. The interesting ones are the public legal acts, and these are the administrative decisions like permits, subsidies, whatever. All the things that are based on the legislation, but that allow you to do certain things that others that do not have the permit cannot do, and legislation. And unlawful legislation can also be a cause for damages, and including the law as part of this unlawful legislation, it can also be the case that there is negligence. So the legislator does not issue the law, whereas it should have. That's the agenda case. I have examples of all these, but I will focus mainly on the administrative decisions and the unlawful legislation. Can you press on the button, please, for the next? Yes. Click. Yes, good. And another one. So I will focus on administrative decisions and the unlawful legislation as causes for damages. Can you click on the next one, please? Well, the child benefit scheme, as an example. Why is that? I already told you a little bit about it. It was about strict supervision on the recipients, but what was actually the cause for the damages here? That's an interesting one. I already said it was mainly based on factual acts. It was strict supervision, but indeed it turned out to be a decision because in the end it was a reclaim of the money. It had huge financially and socially consequences financially because you had to repay the money, but socially because sometimes if you went bankrupt, there is an agency in the Netherlands, child care agency, something like that, that would then go to the court and try to take your child away from you because you cannot take care of your child anymore. So it had big consequences. So the causes are the consequences are there, and the question is what actually caused this, and that is a very difficult one, and I will come back to that later. But it was not so much an individual administrative decision, like the reclaim of money, but mainly this factual behavior that was preceding this decision. Can you click on the next slide, please? Okay, when is a decision unlawful? Or when is legislation unlawful? Well, when it comes to administrative decisions, it is there are two ways. Either the administrative authority admits that it made a mistake, so the ministry admits that it made a mistake, that it gave a permit, that it issued a permit, but it shouldn't have, or that it denied a permit, but later on it says, yeah, you should have had a permit after all. And that can happen in the so-called objections procedure. In the Netherlands, I'm not sure, but many other countries have this as well. So perhaps Indonesia as well. If you apply for a permit and it's been denied or it's been granted, there is an option to object, and that means you go to the administrative body again and you say you made a mistake. You have to give it to me because reason ABC, you did not adhere to the rules or whatever. And then in this objection procedure, quite often, well, the government has to reconsider, and sometimes it concludes, yeah, you're right. I made a mistake. My first initial decision was wrong. If that happens, then we have an objective assessment of the illegality of the administrative decision. The question, though, is whether or not there is a reason for compensation, but I will come to that later. So that's the option one, that the administrative body admits that it made a mistake. A second option that might be more logic for you, that is if the administrative court assesses that the decision is wrong. So after the objection procedure, you can appeal at the administrative court, and suppose that the administrative court concludes, yeah, you're right, plaintiff, the administrative body made a mistake, I will quash now the decision, and it's either the denial, and that means it should have been granted, or it's the issuing of the permit, and that will be quashed, and that means it should have been denied. So that can be the option. Of course, there are multiple other options. Now there is an issue, of course, because you never know who goes to court. It can be the one that is it can be a third party. Pressure group, whatever, but in essence that doesn't matter too much. If the administrative court assesses that the decision was wrong, then that makes it already illegal. But now the question is, of course, when, under which circumstances is administrative decision illegal? The easy one is if it is against the legislation. Quite often legislation is rather straightforward and already gives the boundaries that you have to adhere to as an administrative body. And if you exceed these boundaries, you are in trouble. You are doing something illegal. But there is an issue here, because quite often, and you might know this, administrative authorities have discretion, have some room to maneuver. That's for tailor-made decision making. Is very makes sense, and that means that so you don't violate these boundaries. You don't go beyond the scope of your legislation. But then, so you have some room to maneuver. But in this discretion, there are some guiding principles, like, for example, your own policies. Sometimes you, as an administrative body, develop policies like instructions for your subordinates, for your bureaucracy, or instruction from expert organizations, whatever, that say in situation ABC you must do X, Y, Z, something like that. That can happen. These are policy rules, soft law principles, and these can also be, let's say, guiding principles for administrative behavior. And if you violate these rules, well, these soft law rules, that can be a reason for the government, for the administrative court to quash the decision and to conclude this, what you did, administrative body, is unlawful. Then we have the unwritten norms and the written norms. There are the written norms of good governance, so to say. That is like non-discrimination, don't abuse of power, and all these. What is it again? Something like you have to find all the relevant facts. So due care, something like that. And these are norms that are both formal, they are focusing on the procedure, but also substantive, like discrimination, and they guide the administrative body to do certain things. And if you violate these these norms might also be a reason for the administrative the court to quash a decision. And then the last one, that is actually the most important one, that is the proportionality test. In essence, it is all about weighing interest, balancing interest. The lady justice with the balance. You have to put facts on the one side of the balance and one facts on the other side of the balance, and then you have to make the right decision. You cannot harm or you can harm someone, but there must then be other interests must be more severe that there is a reason to harm someone. Can you press on the button, please? So in essence, it is about this. You are testing a decision, and when testing a decision, you start off with the legislation. Does it not exceed the legislation? Then you take a look at the soft law rules. What kind of rules did you make yourself, public body? Did you adhere to this? If there is no problem with that, you go a little bit further. You look at the substantive and the procedural norms, and then in the end, the decision is either lawful or unlawful. Click on the next slide, please. And that's actually the essential, that's also the essence why it is so difficult to conclude that an administrative decision is unlawful, because quite often the boundaries, here written in red, are more or less straightforward, and quite often the administrative body does not exceed these boundaries. But the issue is that, and that happens now more and more, that the legislator gives discretion, a lot of discretion to the administrative body, and therefore the administrative body can, has multiple options that are not seen as unlawful as such. Here you see with the blue crosses on the line, these are all not unlawful, double denial decisions, and perhaps you and I and we would think, that one is better than that one, but none of these are unlawful. That means, and that's important for you to realize, that for example an administrative court, although the administrative court can think, this was a stupid decision, it's a silly decision, I don't understand why you, no, that would be stupid, because that would be a motivation issue, but it is a stupid decision, but it is not unlawful. It is because the administrative body is allowed to do stupid things now, but is allowed to do things. It is their a task to balance interest and to come to a conclusion, and if the motivation is not too bad, court have to accept that it is not illegal. Although it might feel like a stupid, unlawful decision, it is not by definition. And that has to do with the division of labor, so to say, with the tasks of the administration and the courts. Can you click on the next one, please? So that was administrative decisions, like the permits and the subsidies, etc., etc. Another interesting category is the unlawful legislation. When do we have unlawful legislation? Well, that is an interesting one, because it happens now more and more that especially pressure groups try to involve the ordinary court to say something about the legislation. And the court can then conclude that indeed what happened here, this legislation is unlawful. And why? Well, because, for example, it is against a higher norm, a higher legislation, and that is the case. As you might know, the Netherlands is part of the European Union. The European Union is a separate legal order. That means that the national legislation has to be in conformity with the EU rules and regulations, and it can happen that these EU rules and regulations, they are quite often like instructive to the national governments, like you have to create a law to prevent this and this from happening, and suppose that the legislation does not do what it should. And that can be the case, and that can be concluded in a special case, so to say. And then the outcome can be that the legislation is therefore illegal, is not in conformity with the EU law. It can also be, the legislation can also be against the unwritten norms, including equality. And we had some cases about this. Sometimes the legislator made a decision to make a distinction between two groups, and that turned out to be illegal. And to give you an example, actually I have two. discrimination is a very funny one, because that happened as well, that the legislator identified two groups based on age, but did not have a justified reason to do so. And then the court decided, yeah, well, that is against the non-discrimination principle, so the legislation is therefore illegal, and has to be quashed, or has to be whatever, you cannot apply it. Another example, perhaps a little bit strange, but I will tell you anyway. This was based on the legislation. It was a so-called alcohol lock. That means if you got caught drunk driving, driving while you had too much alcohol, there will be two options. Either you would go to the police, or the police will catch you, and you will be prosecuted, and you will face a sanction, a penal sanction, and that would cost you, well, 400 or 500 euros, or, and it can be also supplemented, you would receive an administrative reaction, and that would be an alcohol lock. And an alcohol lock means that you have to install a certain kind of device in your car, and you had to breathe, and only if the breath does not contain any alcohol, the car would start. And while you were driving, after a few minutes, the alcohol lock will ask you again to breathe, to verify that it's indeed you that's driving the car. Otherwise you would, well, it would be easy to violate this idea, to undermine this alcohol lock. Well, seems like a very good idea, right? But there is a big issue. You had to pay for this device yourself, and this device would cost you 3,000 euros. And the funny thing is that in the process of creating these rules, the legislator said, yeah, we are going to introduce this measure, so to say, and we think that the costs are about 500 euros. And then the highest courts, both the Supreme Court and the highest administrative court, concluded, you balance the interests here, you legislator, you balance the interests, and you say, okay, this device is very effective, it will cost something, as 500 euros, but it turns out to be not 500 but 2,000 euros, because you had to buy it in the market or whatever, and therefore this whole balancing of interest was incorrect. Therefore, the legislation as such is not based on a proportionate balancing of interest, and therefore has to be quashed, has to be annulled, so to say. And now an interesting question is, what is the consequence if the legislation is illegal? Does the court then conclude you have to exempt it in this situation, so you cannot apply it in this situation, or will it conclude that it is non-binding? And you can see the difference between the two. If you say as a court it is non-binding, it is supposed to be never ever exist, or not to have existed. You should not have done it in the first place. If you conclude it's exempted, you allow the situation that it will be applied in other situations. That's a difference between the two. So the most severe interference of the court will be non-bindingness, that you say it is non-binding, because then you say the legislator made a very stupid decision, shouldn't have done it. If you say it has to be exempted in this situation, then you say, okay, the legislation as such might be okay, but you cannot apply it in this situation, and then you still allow it to apply it in other situations, although it depends, of course, on the way you as a court describe this exemption. If you describe it in very regular terms, in very abstract terms, then it's actually, there's not so much difference between non-bindingness and exemptions. Yeah? Okay. That was the legislation, when the legislation unlawful. Can you click on it? On the next slide, please. Yes? Thank you. And this happened a lot. These cases where people try to go to court and to try to convince the court that the legislation is unlawful, and it happened a lot in the lockdown cases. The regulators had to close down the cafes. And the reason was the argument that they made is, the legislation is not based on the solid legislation. So there is a hierarchy and rules, of course. There is formal legislation, and this is more, let's say, a substantive regulation. And this the idea was it's exceeding that one, and it is disproportionate. And the funny thing is, or the interesting thing, and I think it makes sense to you, that especially in times of crisis like this lockdown corona thing, then you see that the court allows the regulator a lot of discretion, a lot of room to maneuver, even if it seems disproportionate, and even if you can doubt whether or not the legal basis is very solid. The court never, again, almost all the lockdown rules and regulations have been challenged in court, but there was no court decision that said, yeah, the regulation is unlawful and you cannot apply this. Therefore, not unlawful. Can you click on the next slide, please? And I already said we have the Urgenda case, and that's an interesting one because there you saw a situation where the court said, yeah, this is unlawful. And what happened there? I already said it's about the carbon dioxide emissions, and the Urgenda, this is an NGO, went to the ordinary court issuing a civil law claim, a tort law claim, saying what happens here is unlawful. And why is it unlawful? Because you, legislator, you state, the state of the Netherlands, you do not adhere to the international agreements that you were part of, the Paris Agreement, and you had to lower the carbon dioxide emissions, whatever. And the current legislation is not sufficient to realize that, and that is seen as negligence. And therefore, an interesting thing, all my colleagues, including myself, thought the court will never accept this claim. It will be very far-fetched to ask the court to say to the legislator, you should do more. But it was quite surprisingly that the court indeed accepted this claim and said, yeah, this is indeed negligence. There is an obligation for the state to commit to its promises, and therefore you have to invoke new legislation that indeed realizes these goals. And that's what's interesting. And by the way, this was, first of all, it was a district court, and then we all thought, yeah, it's just a silly district court somewhere in The Hague. But then they went to the Court of Appeal, still upheld the decision, and even the Supreme Court. So so it's now, let's say, and you could say this is one case, and more cases will follow, because the success of this case inspired others to do similar ways of infringing the political debate, because that's actually what happens here. Here you see that the tort law and the civil court is taking a position in, actually what's in the end politics. What the legislator does and does not do is pretty much a political question. And in this case, of course, there is a reason to lower the emission of carbon dioxide, but there is also a reason not to go too fast, because on the one hand, there was an economic crisis. For example, currently there is a big energy crisis in Europe. We need the gas from Russia, but we cannot get it anymore because there is some kind of war over there. And so you need other ways to create electricity. And one way is coal plants. Coal plants have one thing in common: they emit a lot of carbon dioxide. So there you see there is a balance of interest, and you cannot say or at least that would be my position. You cannot say this interest of the lowering of carbon dioxide precedes all the other interests, including economic activities, preventing us from cold winters, etc., etc. And that is what happens here. The court takes a position and forces the legislator to take to come up with new legislations. And the interesting thing, by the way, is that also very funny. Urgenda is not after compensation. They don't care about money. They just care to steer the political debate in one direction. And as I said, this is one. Yes.
Do I understand correctly that you are saying that the judiciary is like crossing the line?
You could say that. Yeah. At least we call this dicastrocratie. That means it's a Greek word. That means we are governed by the courts instead of governed by parliament. It's a position. I mean, this is an ongoing debate, and there is no wrong and right answer, I think. Because on the one hand, it's also good because there is one big issue that also makes me sometimes a little bit angry. That is the lack of capability of political debates to come to the conclusion. And sometimes it's good that someone takes a standpoint, and say, and we go that direction. And if you want to go another direction, convince me. That's another point of view. So, but you can see here that there's a debate going on. And I did some research on the constitutional position of the courts, and they find it very this position very uneasily. They found not very comfortable in interfering too much in the political debate, because there are more cases like these where we call this lawmaking by the courts, lawmaking by the judges, and they find it very difficult because they always say, yeah, we cannot see the consequences of what we decide here. So we courts, judges, prefer to settle only a small conflict instead of saying something that goes beyond the conflict. Yeah. So it's an interesting problem. And again, this is one, more will follow. And by the way, in this climate change litigation, you see this all over the globe, including, by the way, here in Indonesia, you had a climate case as well, pollution in Jakarta. Yeah. Can you click on the next slide, please? So that was question number one. When is it illegal? When is it illegal what the government does? Well, when it comes to decisions, it is clear. It has to be, someone has to assess the illegality of the decision, and that can be either the administrative authority itself or the administrative court. And then with the administrative court, we already observed that, well, you have to go through some barriers before the administrative court accept indeed the illegality of a decision. And when it comes to legislation, well, then we have the issue of the political position, etc. Can you click on the next slide, please? The mining case, yeah. Why is that an interesting one? Because at first we thought that there is a decision at hand, but the issue is the decision is from 20 years ago. 20 years ago, the mining industry received a permit to extract some gas, and only now, after 20 years, we see the consequences. And that's an issue, because now we see there is a big issue with administrative decisions. If an administrative decision can be the cause of the illegality or the damages, so to say, and therefore might be illegal, we have the problem of the legal certainty. After, if within 6 weeks nobody complains against a decision, we consider it to be legal. That's you understand this. I think you have it in Indonesia as well. There are decisions. There is a period where you have to appeal or to object, and if you don't, we consider it to be lawful. But now the interesting thing is that after 20 years, so not after 6 weeks, but after 20 years, we see the consequences. So was then the decision 20 years ago, was that an unlawful one, yes or no? That is the problem of the formal legality. We see something, we now would say it was an illegal decision, but we still, if we look at it from hindsight, we would say it was not the best decision. And there has the minister by then should have thought about these consequences and should have taken it into consideration, and therefore should have issued a compensation scheme or whatever. And the funny thing is that normally in the past this would be an easy answer in the judiciary. They would say, yeah, we consider it to be lawful because then you should have complained by then. But in the mining case, the Supreme Court said the fact that has legal effect, has formal legal effect, that though we consider it to be lawful, does not form an obstacle for damages. So even though it is has formal effect, it's seen as valid, as not illegal. There can still be reasons for damages, and therefore there is then, and these damages are now based on the disproportionate balancing of interest 20 years ago, and that's an interesting one. So there can be also damages because of something that is considered to be legal, but might have been illegal afterwards. That's an interesting problem. Next one, please. Okay, if we then conclude that there is indeed something illegal going on, then the next step is there a reason for damages? And well, that's an interesting problem, especially for those of you who study tort law. There is always two issues at hand, and if you become a lawyer, these are the two main arguments that you will make, both as a defendant or as a plaintiff. That's one of all, there is no causal relation, or is there a causal relation between the administrative decision and the consequences? And if there is a causal relationship, well, that might be. But then you can always say, yeah, there is an infringement over there. There is a rule being violated, but that rule does not protect you. It's not there to protect your interest, and that's the problem of relativity. You are both familiar with these terms, causation and relativity? Well, I will discuss it a little bit further, so no problem. Next slide, please. First of all, the causal relation between the two. Suppose that you are in the position of developing a big industry, and you apply for a permit. And of course, in the procedure of applying a permit, you have to hand over lots of documents, researches on the biodiversity in the area. I don't know, whatever. You can think of lots of things that you have to prepare. You might even enter into contracts with third parties, the constructor, etc., etc. So you already make costs, anticipating on the potential permit that you will get. And suppose that you will indeed get the permit, but and not at the time that you expected it. Quite often, normally, a normal permitting procedure in the Netherlands officially takes only 6 weeks, but in reality, it can take years before, especially a big plant will start up running, so to say. So there you see that the governmental behavior, delaying, asking for more information, etc., might cause damages because you cannot earn money in the meantime, right? And then the question is what the government does indeed causing your damages? And the answer is no. And this is a big issue because this happened a lot in reality. And so is there a causal relation between what the government does and the damages that you face? And especially when it comes to these procedural faults, these delaying, etc., that is very difficult. Another one is that even in the jurisprudence in the Netherlands, it can happen that the government, I already told you, sometimes illegality is assessed by the administrative body itself. It concludes, we made a mistake, you should have got the permit. Well, if they would write it down like this, we made a mistake, so I admit I made a mistake, and here you have the permit, then there might be causal relation. But what often happens is that, now we did not make a mistake, we made the right decision on the information that we had by then. But now you gave me new information, so now I come to another conclusion. And that's a different way. And if I would be a lawyer working at the government, I would always use the last phrases because that would, then it's difficult for you, the one that is having the damages, to show evidence that indeed there is a causal relation between the decisions. Do you understand the difference? There might be new information, changing your mind, okay, now you got the decision afterwards, or after all, or you just give new motives for the initial decision, so to say. That happens a lot. And actually, so the causation test is in the end, was the administrative body able to make the right decision in the first place? If there is new information, then the administrative body could say, I was not able to make the right decision by then because I have new information. It is, in hindsight, I wouldn't have done anything else different, so to say. But now, with this new information, I come to that conclusion. So that's a big issue. Causal relation between what the government does and the damages that you face, especially with administrative decisions, is not always easy to accept. Can you click on the next one, please? And the same goes with these relativity schemes. The relativity is about a situation where illegality is based on the fact that you did something wrong, you as an administrative body, you violated a rule, a norm, and that norm or that rule is there to protect the one that is facing the damages. And that might seem as easy. I have to put it different. It is easy to accept when it comes to an applicant that went to court, and then the court, so the application has been denied, and after all, it should have been granted. Then it's clear that the fact that what the government did wrong, violated the rule, did not grant the permit or did grant the permit, whatever. But then the fact that it should have done something different is there is based on the fact that it violated the public body violated the rule that protected you. That's the idea. But it becomes more difficult when it comes to third parties that might face the consequences. The interesting case about this shooting in the shopping mall, the victims tried to sue the government, saying, you shouldn't have got issued the permit. And now the question is, issuing a permit, does that also protect others than others than the one that is getting the rifle? Who is then protected by this rule? The entire society? That would be a little bit too much, right? So you understand this? There is a group that is protected by this rule, and are these then the one that is using the rule to get compensation. By the way, in this rifle case, in the end, the court accepted relativity, and why? Because in the decision-making procedure, I have to say it differently. The legislator said to the administrative body in the legislation, you have to issue permits, or you can issue permit, and in the issuing of permits, you have to take into consideration these and these interests. And what were the interests? One of all, the mental capacity of the one that is getting the permit, but also the public order. And then the court said, yeah, in this public order assessment, that includes those who are, yeah, surrounding, in the direct surrounding of the one that is holding a rifle. So if someone with a rifle walks around and shoots you, yeah, then that's an infringement of the public order, and therefore that norm has been violated, and that norm was there to protect you as a victim, and therefore there is a reason for relativity compensation. Yeah. So, but it is problematic. I think you understand that one, right? So causation and relativity. These are two issues that are derived from ordinary tort law. In ordinary tort law, it's already a big issue, but when it comes to administrative decisions, and whether or not there is reason for damages under administrative law, that's even a bigger challenge, so to say. Can you click on the next slide, please? And then the procedure, and I think that is also, that might be perhaps the most interesting for you. I'm not sure, but here you see that there is some development going on, because in principle the Netherlands has a system of a closed jurisdiction over administrative decisions, and that means that administrative decisions have been decided upon in the end by the administrative courts. We have an ordinary court. That's how they call it in the legislation and the constitution. There's the ordinary court that you can address them always, so to say, but the ordinary court will deny you your case if there is an other procedure, and that other procedure with all the safeguards, etc., is the administrative court when it comes to administrative decisions. So when it comes about the validity of an administrative decision, you have to go to the administrative court. That would mean, and that was the situation in the past, that if you face damages due to an administrative decision, you had to go to two courts. First of all, to the administrative court to get it quashed, to have an assessment of the illegality of the decision, and then if the court indeed accepts your claim and says, yeah, this was illegal, then you would have to go to the ordinary court, to the civil court, to get your damages. Well, that's not very customer friendly, right? It will take years, first of all, to get the decision off the table, and then years to get the damages done, right? You can understand this. But this is the let's say, option number one. That is the starting position. But luckily, you could say, the administrative courts were a little bit, well, also convinced that this was a little bit too much. So a practice emerged that administrative court would also say something about the consequences and the damages and the need for compensations of these damages, so to say. And that is now also in the legislation. That means that there is a special procedure, and you can, so under a procedure where you try to quash a decision, you can, and that doesn't have to be in advance, that you can do that during the procedure. You can add another claim saying that, yeah, this is illegal, and the compensations, and I want compensation for the damages that I have. And then you provoke the administrative court to say something about the compensation, and also to assess the amount of money that you would need to compensate you. So here you see that the administrative court is exceeding its powers, and it's now in legislation, so it is allowed. So the ordinary court has now, less jurisdiction, you could say. The administrative court has now some more power to say something about that. And so it's now in the General Administrative Law Act, this special procedure, and it's now a few years ago, and we are now in the phase of evaluating what actually happens, because there are some problems here. I'm sure you understand. Next slide, please. And these problems are actually that you now have two captains on the same ship, because you still have the ordinary court procedure. So first we will have the decision quashed in administrative court, and then we will go to the ordinary court to get the damages. And we have the alternative route, adding a claim based to your claim that the administrative decision is illegal at the administrative court. So two captains on the same ship, and that's problematic. That is problematic by definition, because you know one thing for sure: that these two courts will never agree on, no, I will have to say it differently, because it's not that they do this intentionally, but there might be different outcomes in terms of what is illegal and what's not illegal, what is the amount of damages that you faced, when is there relativity, when there is there causality, when what is the type of evidence that you have to show to prove to me that you indeed need compensation. You understand this, I think, right? So two captains on the ship is never a good idea, because they all want to go a different direction, and that is the big issue. So, for example, suppose, and you already have this more or less, if it's in the situation where when a decision has legal effect, so the administrative court cannot say anything about it anymore, then you now need to go to the ordinary court, and then see the mining case. The ordinary court, cannot say it is illegal what happens here, but still can say there needs to be some compensation because because the balancing of interest by that time is disproportionate. But then he actually says it was illegal what happened over there. So that's a difficult one. And think about this issue of the interested party. When do we accept relativity? Well, the rival case, there you saw that the ordinary court accepted relativity. Well, I doubt that an administrative court would accept that. The administrative court is way stricter in this regard. And of course, well, think about the differences in, it might be very stupid, but in the end, it's all about money. Suppose that the same case would end up in 20,000 euro compensation at the ordinary court and only 10,000 in administrative court. That is something that you don't want, because then you you get forum shopping, etc., etc. In general, we think that administrative courts are more accessible because you don't have the obligation to hire a lawyer to go to the court. But in these cases, you almost practically it's impossible to do it on your own. But in principle, it's not. And we think that the administrative court is more customer friendly. But I doubt that is the case in these, especially when it comes to money, because then the courts often rely on the parties to provide evidence, etc., etc. Can you click on the next slide, please? And then I have some practical notions. What you see is that the administrative court is seen as often more accessible, and I think that's the case. And what you see now also is that because in the past, actually very recent past, the whole idea was that the administrative court was not easy to accept illegality of the administrative bodies. They were seen as, let's say, almost almost a part of the government. But now you see a more critical approach of the administrative court. So, in essence, it's not a bad thing that the administrative court is trying to fill the gap, so to say. And and another practical notion that I want to make is what you quite often see in the Netherlands is that if we have a situation of illegal activities like this mining case or the child benefit schemes, then quite often the government comes up with a general scheme to compensate for the damages. And then illegality is a given, so to say. The fact that the government made a mistake in the first place is then seen as a given. And to give you a more specific example, both of the mining case and the child benefit scheme, in the mining case now, the legislator created a special procedure with special courts, with special procedural rules, that everyone in the mining area, it was identified in which area you could claim, who faces some kind of problems, a crack in the wall, or even a collapsed house, so to say, had to can file a claim in an easy procedure. Then there would be an expert coming by assessing what is the case, and that is then seen as an easier procedure, etc., etc. So sometimes you see special procedures popping up, especially you could say in the mass claim situations, and the same goes for the child benefit schemes. I already told you the government collapsed due to this scheme, and and that also meant that the government realized that it made a big mistake. And what happened then is that on a Friday afternoon, they decided to give a generous compensation for all those who say that they are victims. Everybody would get 40,000 euros. That's quite a lot of money. Even if you if you had less damages, you would get these 40,000 euros. And if you had more damages, then there will be a special procedure again with a commission, etc., etc., to identify what's actual your damages and to figure out how to compensate that. So that, I'm done. So because my next slide is, thank you for your attention. Click, please. Yes. So very good. Thank you so much. Well, thank you.
Okay, thank you, Prof. Tolenar. Before we move, prior moving to the Q&A, I would like to invite Mas Rico to give your material and to speak for maybe like 30 minutes approximately before we move to the question and answer sessions. Thank you.
Thank you, Mas Budi. Good morning, everyone. In here, I would like to greet my head of department, Ibu Dwi Haryati. Also Mbak Ayu ya, from UII, and also many students join with us. I would like to continue the discussion provided by Pak Albert Yan ya. By the way, Pak Albert visit us for strengthen the cooperation for academic cooperations between Faculty of Law UGM and Faculty of Law Groningen and then I report about his visitation to the department, administrative department, and then we initiate to conduct this kind of seminar so we can obtain comparative insight about legal developments on the issue, particularly on the issue of tort conducted by administrative body. We see that next slide please, Mas. So actually it is because of the context is we have Indonesia. Indonesia has we can say positive developments on this matter. We in certain aspects I claim that Indonesia has taken this is too small perhaps you can you can read it, okay, because I need to read on my screen here. Usually generally speaking, when we meet Indonesian legal scholars, meet with the Dutch legal scholars facilitated by the Dutch embassies in Indonesia, they always start with the introduction saying that between Indonesia and Netherlands we share what so-called legal DNA. Okay. However, I have a preliminary hypothesis for this matter that we and Indonesia has developed different trajectories with what has been developed by the Netherlands. This assumption is based on the idea who drives or who created Law number 13 2014 about administrative Government Administration Act. Because at that time the intellectuals behind the or locomotive intellectuals behind that regulation, behind that act, was led by the professors from administrative science rather than from the administrative law. So they have their own. We are competing, or we are debating between administrative lawyers and administrative scientists, social scientists. But then the decision is led by or won by the administrative scientists. So from that starting point, it has already saved to have a preliminary assumption that we have different trajectories with the Netherlands. And then after seeing the presentation provided by Pak Albert Yan, I more confidence to say that. However, I think it is still too early to claim that my presentation is a solid finding, but at least I try to attempt the preliminary findings in here. Next slide, please. Previously, perhaps some of you already know about the situation that previously dispute regarding tort or unlawful acts was always under the competence of the ordinary court, and it was under the logic of private law argument. Article 1365 of the Civil Code. And it happened disregard dispute among private parties or dispute between private parties or individuals and public bodies. So, albeit the context is suing the government or public bodies, they are still using or utilizing these arguments. As I mentioned earlier, this shift started in 2014 when the government passed a bill on government administration, which indicates that the administrative court has a competence to review the legality of government action. Nonetheless, it takes 5 years to really secure that situation. So until 2019, next slide, please. Until 2019, it is actually on the middle of 2019 that the Supreme Court released a regulation, clearly stating that explicitly that the ordinary court shall forward the administrative court to the administrative court regarding to any petition or on tort conducted by the administrative body. So we have 5 years in transition where the Supreme Court worried which area that whether it is should be handled by the ordinary court or administrative court. So that's the context. That's the context. And then next slide, please. Again, this is the development. So in essence, I would like to I do not want to explain everything, but previously, administrative court has a very limited function. It is only has jurisdiction to review the legality of administrative decision, right? Currently, it is not only administrative decision, but also factual government action. Factual government action. And what is meant by factual government action in here is implemented very broadly. Very broad, it is referred to either to do or not to do. This is important, or this is a very important statement, according to the Supreme Court regulation, because later on I will show you the inaction that is later on sued by the NGOs, and then the case was won by the NGOs. Next slide, please. Previously, we have administrative decision in what is meant by the previous regulation has characters of concrete or real, individual, and final. But now under the current regulation, now it is okay to review. It is reviewable to have abstract individual decision, which means that decision regulate requirements about permits, about government aid, the persyaratan itu persyaratan itu the requirements, albeit it is not regulated on the regulations, it is regulated on the soft law, guidance or decisions. It is also reviewable on the administrative court, or decision type concrete and general, for instance, for which apply to certain segmented individuals. For instance, regional minimum payment, UMR, upah minimum regional. Nah, itu juga that's also part of the object jurisdictions of administrative court. However, for the abstract general, which is regulation, it is the competence of Supreme Court to review. We know about this, right? Okay, next slide, please. The other differences is that previously, according to the previous regulation, it is really focusing on if a public body does not issue the decision within 4 months, it shall be meant as a rejection. That was the regulation. However, in the current situation, we adopt what's so-called lex silentio positivo. If the public body does not issue requested decision within a determined period, the request will be considered as approval. Nah, ya kan, as approval ya. However, the applicant has to legalize this on the administrative court ruling. Ya. Next slide, please. Ya. Nah, next slide. Ya, itu betul. Ya. So this is some good signs. I will show you some good signs of positive development in the last couple of years. Yeah. For instance, when the government was sued by the NGOs because the government conducted throttling of the internet access in Papua. Yeah. So internet access in Papua was suspended for approximately 6 weeks. Yeah. 6 weeks. The government at that time argued to prevent the hoax, the misinformation that passed between one individual to others occurs in the Papua, and then to prevent racial riots in Papua. Yeah. However, that's also causing the work of journalism prevented. Yeah. Hence, it is very dangerous for Jakarta, for the policy makers in Jakarta, because they only obtain information from one side, from the military officers. They may have no idea about the additional alternative information which may be provided by the journalists, by the NGOs, etc., etc. Yeah. So according to the court decision, no, the government, you have to create clear regulations about that matters. Because you do not have a clear regulation on that matters, your action is deemed unlawful. That's what he said. Yeah. So that's some good signs, meaning that that's at least we have what judicial control towards the discretionary power made by the government action. Yeah. Another positive sign, for instance, when the governor of Jakarta sued by some citizens because of not conducting normalizations of the river properly. So the river is quite long, but then the governor only, the province only look after for certain kilometers rather than the full length of the river, and then people disagree, and then some of these people sued the governor. And then the governor said that at the time, Anies Baswedan said that, okay, we will follow with the court decision. That's also a good positive sign. Another one is this is still working. We cannot see the decision yet, the court decision ruling yet. When the NGO, legal aid NGO, sued the Ministry of Health and Ministry of Information Affairs, regarding to the how to say that, the smartphone application Peduli Lindungi, application for implementing curfew restriction. So we have to tap on the barcode, and then they argued that it is not safe because our data is not protected, and then forwarded to the other parties. That's infringing our privacy, etc., etc. But we are still waiting. We are still waiting of the court decisions. Or the other cases, it's still also waiting. The government has been deemed conducting maladministration according to ombudsman, because the government directly appoint the head of local regulation, the head of governors or the mayor or the regions immediately without having a proper fit and proper test. Yeah, there is no clear guidance, clear regulations which can guide on how to replace the governor, mayor, and regents. Yeah. So NGOs have submitted this to the ombudsman, and ombudsman consider its maladministration. But then it seems that the central government still reluctant to conduct in certain ways. So the government, the NGO has a plan to sue the Ministry of Homeland Affairs in a short coming period. Now this is my one or two slide last of my one or two slides. Yeah. So we can see at least the positive developments during the last 2-3 years, yeah, about the real or factual situation on the court about these issues. However, we can see also critics in here. Some of those are written in here. Some of those still on my mind. What I mentioned in here is, yeah, the administrative court may not be fully convenient for the justice seeker, because the justice seeker may only obtain maximum damages, maximum compensation for 5 million rupiah, which is too low. It's only 320 euros. Yeah. In the Netherlands, you may not rent for one room with the 320 euros. It's usually about 400, right? So it is too low. Yeah. And to certain extent, I evaluate or I conduct a mini research. I don't think that there is any court decision which exceed this amount. So the court still stick to the this old ancient regulation. And then justice seekers may find it difficult to access administrative court because we have 37 provinces, yeah, currently. However, we only have 28 administrative court, first instance of administrative court. Yeah. Meaning that not all provinces have a representative of the court, and only 4 appeal courts in Indonesia, which makes harder, yeah, to get that. Yeah. And I think one point that I haven't written, I do not write in here. I think there is a necessity for the academia to guide the judiciary, because the argumentation that they develop on their ratio decidendi has to be compiled, has to be synchronized, yeah, in order to ensure clearer predictability of the future decision. So the discussion that previously suggested by Pak Albertian, yeah, may not be available in the current situation in Indonesia. So we do not have discussions about proportionality principle, for instance, whether or not this is important or not, duty to give reason, etc., etc. You know, that kind of debate is still, it is available, but it is not as strong as it is expected. So future research need to be conducted about it. Last one, my last slide, please. I just want terus. Sudah selesai ini semua. Ya, yeah, thank you and keep in touch. Assalamualaikum warahmatullahi wabarakatuh.
Right, thank you, Mas Riko. So I would like to conclude several points before we move to question and answer sessions from Professor Tolonar and Mas Riko points. So the first one is factual cause is very crucial to determine liabilities and damages, especially in Netherlands administrative law. And there are some points which is proportionality test, which is required for discretions to weighing, to determine whether benefits bigger than the harm actually, and then and practicalities in admin court is more accessible in the Netherlands, and when to accept relativity is very hard to determine because the admin court is very strict, if I'm not mistaken, Professor Toronar. And then for Indonesian one, regarding master presentations, there are a lot of challenges in Indonesia administrative procedures and court, especially because, as we all know, that out of 37 provinces, only 28 province has administrative court, and only 4 administrative higher court, the PTTUN, to file an appeal. And then, as we also know that some cases in Indonesia related to the administrative issue, for example, when the government tried to turn down the internet and electricity connection in West Papua, has become a very landmark decisions and development in Indonesia administrative law. But several points that made by Professor Sonal actually will be good or beneficial for Indonesia administrative law in the future, but do some extensive research in the future again for development as well that we adopted in Indonesia. Now, I would like to open a question and answer sessions for students. I know this topic may be relatively new to you guys, especially in administrative law. Is for the Netherlands part, but just try to, if you want to ask questions to Professor Tolenar or Mas Rico about the administrative law in Netherlands or maybe in Indonesia, feel free to raise your hand. You can use Bahasa, and I will try to help you in to translate it to English if you want. So yeah, I give you some time to think and to try to ask questions. Every question, any questions?
Yeah, because just for clarification, you say in Indonesia the administrative court is also entitled to say something about the legality of factual behavior of the government. Yeah, and what is then still the room for the ordinary court? Is there also an ordinary court procedure to get compensation or not?
No.
Not at
Since 2019, it is not possible because the Supreme Court regulation explicitly mentioned that all the case regarding to the tort conducted by the administrative body shall be forwarded to the administrative court.
Okay, and your point of view is that with that decision, it is less easy for citizens to get compensation because we have less administrative courts.
Yeah,
Less, and perhaps also the compensation is lower.
exactly.
Yeah, that's an interesting
Exactly.
perspective. Yeah. Yeah. Okay, thank you.
Right, thank you, Professor Trana, for the questions. So yeah, I would like to, would we? Right. Terima kasih Budwi. So, Professor Albertian, this is Budwi. She is the head of Department of the Administrative Law, and she would like to ask several questions. The first one about the responsibilities in comparing Indonesia and Netherlands unlawful act in terms of administrative law, and where to file compensation. Try to compare it, and then what kind of administrative action that can be done if there is an unlawful act in Netherlands, especially. And then for the unlawful act itself, is there does compensation is being limited? Is there any maximum or minimum or not? So yeah, those are a few questions.
Is it part of the administrative code or civil code?
Yeah, that's a difficult one. First of all, the compensation. There is no maximum compensation that you would receive at the administrative court, like you have apparently here in Indonesia. There is, though, the idea is that you would get more compensation. The idea, huh? So that is something that we can test when we have more cases in the civil court. I mean, and that's the reason is because traditionally, the administrative court is there to assess balancing of interests and accepts the fact that you need to accept something in the public sphere. Huh? That's the idea, and therefore, some loss is inherent, and that's the idea. And in civil court, the idea is every loss that you have should be compensated 100%. So that's the assumption. So we have to test this in the future situations, and the idea will then, of course, be that if we have more cases and we see that some people go to the administrative court, some people will go to the private court, to the ordinary court, then we might see differences popping up. And my assumption is that you would get more money at the civil court. That's an assumption. We have to test this. Your first question on the comparison of Indonesia and the Netherlands. Yeah, on a certain level, we can compare, I think, because we both have the situation that the government does something wrong, or at least causes damages, causes harm. And then the question is where to get the money, to put it very bluntly. And an interesting thing is that in the Netherlands we see a tendency towards more jurisdiction for the administrative court, like Indonesia, but the starting point or the rationale behind it is different in Indonesia. As you say it is mainly to keep the citizens away, to lower their options, to make it difficult. More, I exaggerate a bit. I don't want to say what, to make it more difficult, so to say. Whereas in the Netherlands, we say, we want to create let's say a one-stop shop. Only one procedure, and then you got everything, instead of having multiple procedures and lengthy procedures, etc., etc. So the starting point is different. That's an interesting thing that I observed in your story. And then the issue is, and that's really a question for you. Do you then have similar problems like causality and relativity that now are part of administrative law procedures, whereas they did not do that in the past, or is that not an issue at all?
Yeah, in order to saying that the government has conducted lawful or unlawful, of course, the court has to conduct assessment about the causality, whether the action is necessary or not, whether the action has been conducted with a careful way, due to carefulness, etc., etc. That kind of mechanism is assessed.
But that's only about the lawfulness of the act. That
law of the act. We also based on the principle of good administration as well. But what may be not strong enough is on the argumentation on. So they have on their mind, but they have to explain it on their paper as well, so we can understand about the rationalization of the court, why they are taking such a decision. So they are claiming they are reviewing about duty to give reason for the administration, but they themselves do not provide sufficient reasoning on the court decision. That's my point.
So that, but that's still that can develop, of course. But interestingly, what you say now is that there is still a debate going on what is legal and what is illegal. But what we now also have, because of this whole tort law in the administrative law, is the question of if it is illegal, we accept that it is illegal, is then there a reason for compensation? And then you have the issues of causality and relativity. Something can be illegal, but still do not qualify for damages because there is no causal relation between the two, or the norm that's been violated does not protect you, etc. Do you see that as well in your case law already, or is this something that would be a problem in the way the administrative court will deal with the damages or not?
Yes, for the Papua case internet connection, for instance, at the very beginning, the NGOs do not interest to claim the compensation because, first of all, it is so limited, it is not interested. The second one is their objection is to like naming and shaming and preventing the government to conduct similar mistake. That kind of things.
That's a very good example, because that happened also with Urgenda, and then they did not ask for compensation because they were not in there for the money. They were in there to, as you say, naming and shaming, change the political debate. But what is interesting then is still there might be a relativity issue. I mean, this NGO must then also be existing because of the interest that's at stake here. To put it very bluntly, Urgenda could never challenge the decision about internet connection because that's not, there's an NGO aiming at climate change issues, so not on privacy issues. You understand what I mean? That's also a relativity issue. Does the norm be violated? Is that something that you are there to protect, so to say? That's also a relativity question. A different one, but it's also a relativity question. Then you asked something about the oplossing theory.
I try to translate because.
But I don't really get this issue. What is the issue here?
But Ibu Dwi asked, because at least from the Indonesian perspective, government action can be conducted in a full public law, based on a public law, and also based on public law, but leads to the private law action, contract, government contract, for instance, so in terms of the these separations, which is this also will cause on the differences of the judicial procedure. For instance, one go to the full administrative court and another one go to the civil court.
Now I understand a little bit better. I think on a theoretical level,
Bu ya? Maksudnya pertanyaan itu ya?
I think on a theoretical level there is a clear distinction. Indeed, the administrative court is mainly interested in the public norms, and therefore will try to search for the public norms that violations of these public norms. But in practice, there's now a colleague of mine wrote a very interesting inaugural lecture. He said that in the interpretation of these public laws, quite often the administrative court is adhering to these private rules and regulations as well. So it is a little bit, again, Ulpiana said there was a clear distinction between the two, but in reality, it's almost all common law, right? We know what is fairness. It's in the end all about fairness, right? And then, they phrase it as part of public law, but it is in reality it might be a little bit private law after all. But it is very difficult to pinpoint this, so this is an interesting debate, and I cannot make it more clear than this. It's a big issue.
Anyone else want to ask questions? Yep, go ahead. You want to do it in Indonesia? Or? There's no maybe. Ada.
Thank you. Okay. Good afternoon. My name is Nalia. Prof. Tolinar concluded that there's a complexity when one tort case is proceeded in two courts. The judges can have different decisions. So I want to ask whether forum shopping is allowed in Dutch. A person can sue in different courts to get the best or favorable decision for her or him. Is this allowed in Dutch? And the second question about nebis in idem principle. If a same case is judged in two courts, this will violate such principle. If this, I'm curious whether this principle can be violated in Dutch.
Good
For
question.
Mas Riko,
Yeah, good
thank you. Can I ask one question for Mas Riko? For Mas Riko, because I teach private law, so my question is, can we still use Article 1365 Dutch Civil Code to make the compensation more reasonable? Or are we bound to use the law number 30, 2014 to determine the compensation? That's my question. Okay, thank you.
These are all interesting questions. Also the last one, I'm very interested in that one. This forum shopping, is it allowed? Well, in general it is nowadays. And the idea is that you have the choice either to add your claim, your compensation claim under the administrative law procedure, or you wait and see, and later on you will file a new claim under at the ordinary court. So it is allowed to shop, but not in the same case. I mean, once the administrative court decision has been made, you cannot not add another claim because it's done already. Then there is only one option, that's go to the civil court. So it's not that you can claim, you cannot go for two routes at the same time. You must make a decision while there is still this court decision pending, so to say. And then nebis in idem, yeah, it's a good question, but nebis in idem is a criminal court norm. It is about you cannot be sentenced twice for the same crime. And so it would be difficult to apply this in this situation. Suppose that you would go to you would add your damages claim in the administrative court decision, and you will get some kind of compensation, and you're not very happy with that. You didn't think it's not enough, so to say. Then your idea was then perhaps, can you then still go to the ordinary court to get some more compensation, right? I think it's possible, but I think the civil court will be very easily done with it and say, yeah, you had your chance in the first place. You do not provide more evidence or different evidence. It's done now. In normal situations, I'm not sure you're a civil lawyer yourself. I think if you would end up in a court decision claiming your damages, and the court gives you a certain amount of money, and it turns out that you had more damages, you can still add a new claim. I think it's possible, right? So that kind of rationale is applicable here as well. Yeah, does that answer your question? Okay, and now you.
Yeah, I think it needs to conduct longitudinal research, in order to provide clear picture about this matter. But from my short observation, it seems that I found at least two blur picture. The first one is the administrative court is reluctant to provide damages, to provide compensation. Secondly, if they provide, it is usually below the ceiling. So maximum, so I saw 3 million, 4 million, 5 million, and that's all. Yeah, I never see any compensation granted above that ceiling. That's the number. That's one point. The second one, there is still a confusion, or perhaps will be a future debate in Indonesian judiciary, because NGOs have a tendency or making a reroute, to challenge the government action by submitting citizen lawsuit based on the ordinary court. So it will raise a concern to the judiciary whether citizen lawsuit in here may be tunneled into administrative court under tort conducted by the administrative bodies. Um, However, I haven't found any case on CLS. The debate has been going on the NGOs. I observed about that one. I was invited by them as well. But I'm at least up to now, they are still, moving forward and then backwards. you know, not determining whether they will go with the CLS or with the tort conducted by the administrative body.
May I ask a follow-up?
Sure.
Because the question was like, does the administrative court then apply ordinary court rules? And that's the case apparently, or not? Is there a special court procedure for administrative courts?
No. When examining about the whether or not the compensation shall be granted, it is utilizing the logic of civil code procedure.
Okay, yeah.
Okay, there is liabilities, and because of the liabilities has been conducted by wrongful acts, and therefore it has to be obtained compensation. So that kind of logic stem from the civil code procedure.
Yeah.
But then it is fully applied by the administrative court since 2019.
Yeah. But substantively, it's the same as an ordinary court. Hey, you have to provide evidence, you have to, etc. These kinds of rules.
Persis.
Yeah. Okay. Clear.
Okay, so one last questions before we end up the Q&A sessions. No? Okay. Is that clear? Okay, good. So thank you, everyone. I would like to give the time back to Master of Ceremony, Mbak Gaby. Yeah, I would like to give you. Thank you.
Okay, thank you, Mas Budi. And once again, let's give a round of applause to the speakers. It is our hope that the audience here enjoyed, of course, the discussion. Now, as a token of our appreciation, we have a little gift for Prof. Tolenar, and perhaps Budwi or Mas Riko would like to hand out the gift. Budwi, then. And perhaps we can call the media team to take the photo session. I would also like to remind for the participants that e-certificates will be given out if you already fill in the presence form. So yeah, so we have come to the end of the event. Hopefully today's seminar can give a positive impact and valuable impact, of course. We also would like to once again thank you so much for everyone who have come to this seminar today. Also, thank you for the speakers and the moderator. We would like, thank you for the time and dedication devoted for today. Last but not the least, thank you also for Mas Budi for moderating today. On behalf of the entire organizing committee, we apologize if there are any wrong words or anything lacking. I, Gabriela Jocelyn, as the Master of Ceremony for today, would like to say thank you. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, best wishes to all of us, and see you next time. Thank you.